Hello? Hello?
Hi,
Oh, good. You can
is
hear
this
me.
Bernie? Bernie?
Yes, you can hear me.
Oh, okay. I'm I gotta organize all these papers. Now I can't find what Merlene sent.
Hello. Hi,
Hello, how are
everybody.
you?
Good, thank you.
Mommy, can I be cold? No. Is 50 minus 30 having 21? 50 minus 37? I'm thinking
No, you pay when you come.
Oh, well, I mean, I got here at 11 when it opened.
And you got the ticket at 11:19.
Good afternoon, everyone.
Hi, Janice.
Hi, everyone can hear me?
Meter. So when you come, you
Yes.
Yep.
Okay, good.
You know how long.
I mean,
Today we're going to start with recommendations from the Policies and Procedures Committee.
so I have to pay a $10 fine.
I think Katrina needs to mute herself.
Yeah.
Hold on.
Hold on, wait. Did she do it? Yes. Remember last week we had two subcommittees present their recommendations. Well, this week we're going to have two more. If we can get a third one in, maybe. But we want to have time for feedback from the larger committee. So we're going to start with the Policies and Procedures Committee, and that chairperson is Bernie. Bernie, are you on?
Yes, I'm on. Can you hear me?
Yeah.
Was that it? Can you hear me well, or you can't hear me at all?
You're a little low.
Okay. So I'll try to speak louder.
Okay.
Because I think that that's often the problem. I'm going to screen share. We're going to have other committee members, in addition to myself, participate. It says host has disabled participant screen share. I need the host to allow for screen share.
Okay, it's allowed. Is Marlene on?
Yeah.
Marie. Marlene.
Oh, no.
Okay, everyone. Good afternoon. So this is the Policies and Procedures Subcommittee, and we're going to cover the policies that we've looked at so far, which we've received, which is the field stops, response to resistance, the Bass policing, video recording of interrogations, body-worn cameras, firearms and personnel complaint, and also strip search and body cavity search policies. We received additional policies, but we haven't gone through them at length yet, so they will not be presented or discussed today. We will focus on a few of the policies, and the members can talk to any of the other policies that we may not have listed here in the presentation. So part of the committee is Marlene Chevette, Janice Griffith, Patrick McCarchuck, myself, Bernie Toms, Marie Vitale, and Richard Wilstatter. Today we're going to cover these policies as listed, as you can see. First, I'd like to turn over to Marie. If you're ready, you can begin to cover the body-worn policies. We have Richard Wilstatter, who will cover field stops and resistance to response to resistance, and I'll cover strip searches and personal complaint. But we'll all at any given time be able to discuss with you and give our own fine points. In addition to Janice, who is on with us today, she can also add into anything that may be presented or missed, or that we'd like to add in individually. So we'll start first with the body-worn camera policy, and that is Marie Vitale. Marie?
Okay, hi. So let me just start out by saying that none of these recommendations are all encompassing. We pretty much picked out the most important ones that we thought, and certainly with the expectation that there would be more from the greater committee, or even from ourselves if if we decide to go through it again. But the body-worn cameras, Okay, I'll start with that. And most of this information was taken from the pamphlet of policies and procedures that was given to us in the beginning from Chief Castelli. So that's where we got the information, most of it. Okay, so my first point would be that there was a recent study done on the use of body cams by the NYPD, and the response was overwhelming that body cams are a powerful tool for increasing transparency and accountability for officers, the public, and police officials. The mere fact that an officer is wearing one and that the public knows he's wearing one really cuts down on many complaints. So if we have the technology, it should be used to the fullest extent. These are the observations that we've made. Number one, all officers should be trained and authorized to use the body cam. And I think it's the Taser Axon Flex, whatever it is that that the department is using. But everybody should know how to use it, even if they're not using it at the moment, if they're working indoors or something like that. Every officer who's in the field should be equipped with a fully functioning body cam during his tour of duty, and it should be activated during every civilian stop. Whenever there's an incident involving an officer that the officer reasonably believes will lead to a civil complaint or civil litigation, there should be a negative inference drawn if the officer's body cam is not activated. So basically what it says is we have something to hide, and that's why it wasn't activated. Recordings of all body cams should be kept for a minimum of a year, I think currently it's 6 months, or until any civilian complaint has been resolved, whichever is longer. I know that these keeping these things takes up a lot of space, I guess virtual space. I'm not really sure how that works, but it's something that should not be too onerous on the department. Whenever an officer records an incident that he reasonably believes will result in a civil complaint or action, the officer shall report to his commander the existence of such recording as soon as practical. And that doesn't mean in a week. It means, when he gets back to the station or when the commander's available, etc. The recording should be secured and a report of its contents made available to the district attorney's office. If the district attorney's office will be investigating those incidents, unless there is another body that will be doing that with the new DAs. But anyway, it should be made available to the DA's office, any special prosecutor, the mayor's office, and any civilian complaint review board that is formed. Any recording should be made available to the public unless there's an ongoing or an active investigation or an incident involving sensitive matters such as sex crimes, domestic violence, juvenile arrests, or other sensitive matters. And that should probably be made more specific because it does lead to interpretation. So it's just, it's thrown out there. And of course, any violations must result in sanctions to the violator or to the department, whichever is appropriate and to the appropriate extent. It doesn't mean that, the failure to turn on a body cam one day will result in immediate suspension. However, there have to be sanctions. Otherwise, the rules are just useless. So the overall concerns are that the department should use the body cams to the greatest extent possible. And if there's any question about whether or not they should be used, the presumption should be that yes, they should be used because using them we'll definitely add transparency and accountability to the department. And if you, I mean, all these things are written out as Bernie's done. So for any further clarifications, you can look at that. But that's really the overall, those are the overall recommendations and concerns. Some of them may not be practical, but, you know, again, it's subject to presentation to the whole committee. So anybody have any questions? Okay.
Nada?
I have a question for you, Marie. Thank you very much. I guess my initial reaction is that well, it's tricky because I don't see what the existing White Plains police body worn camera is. So I'm just surprised that some of these that you're recommending are not already White Plains Police Department policy. So that surprises me. But
well, I think the body cams are a relatively new, a new thing. I don't know exactly what year they were instituted, but it's certainly not something that has been used for, you know, 20, 25 years. And any police officers on the committee could speak to that. Certainly any the captain or chief. So I guess they were still new, is my guess, when these things were done.
Marie, we started the implementation of the body cam program 2015. We were the first in Westchester County to have body cameras, and we implemented them before NYPD. As a matter of fact, a couple of NYPD precincts came up and viewed our body cam program. And to Nana's point, there are several of these recommendations that are already in place. But I do get your point that without having our existing policy matched up with the recommendations, it's pretty, it leaves you with a sense that why isn't this done already?
Right, right. Well, one of the things that I think that we all agreed upon that this manual, if that's what you want to call it, some of the stuff is written, some of the language is kind of vague and they do lend themselves to interpretation. So, I mean, if this is going to be rewritten or reworked, certainly whoever is going to do that should really should try to be more specific about these things. Some of them are repetitive, some of them are vague, some of them seem to contradict themselves at some point. And so again, you know, I don't doubt what you've said, Captain Spencer, but they should definitely be fine-tuned. And I'm glad to hear that the NYPD learned from White Plains. Yes, that's good to know.
I agree with you, Marie. Some of the policies are vague and do need tweaking. Thank you.
Okay. Anything else?
Okay, the next, we'll move on to, if no one else has any other questions right now, or any of the other committee members have any comments to make about this particular policy. So next we'll move on to the overview of the firearm policy. And once again, Marie is going to provide us with some comment to that.
Okay, so first let me say again, these recommendations are not all encompassing. I also, I think none of us in the subcommittee really discussed like the technicalities of gun safety and training and all that. I mean, for myself, because I don't really know any of it and I don't know about anybody else on the subcommittee. So I don't know guns, but we will speak to generally the policy, firearms policy, which I took to mean the use of deadly force or the use of a weapon against a civilian. And, you know, anybody can correct me if I'm wrong, especially those on the force. But in just reading it, Section 1 or Section A says that under departmental policy, an officer may use deadly force And again, so I read deadly force as drawing a weapon or gun, when he reasonably believes it's necessary to prevent or terminate the use of deadly physical force against himself or another person, or to prevent serious physical injury to himself or a third person. And serious physical injury is serious physical injury. It's not, you know, a shot in the foot or something. It's something that causes substantial risk of death, or which does cause death, or serious and protracted disfigurement, protracted impairment of health, impairment of bodily functions, etc. And that's taken directly from the penal law. To me, that should be the only standard that's used. So there was another thing in here, section 1B, that an officer may use deadly force in effecting the arrest of a person he reasonably believes has committed a felony in which the use of threatened imminent use of deadly physical force has been used by the subject. That's very vague to me. And again, I don't know that you would need further clarification if you stick to the law, to the existing law, statutory law under New York state laws, and also the case law under state law and federal law. So that, and it also seems to say, and again, you can correct me if I'm wrong, that an officer may use deadly force or shoot someone if the person has already committed a felony. And that, you know, to our mind would mean that an officer is, you know, acting as judge, jury, and executioner. And if it means something else, again, it's very vague, because I know that there are some other, there is language there. And that's on the outline.
Can I jump in for 1 second, Marie?
Of course.
I'm glad you quoted the New York State Penal Law, Section 10, for the definition of serious physical injury. That Section 1B is taken directly out of New York State Penal Law, Article 3530. And actually Section 1A and 1B are both taken from Article 35.30. And so our policy lines up directly with the New York State Penal Law.
Okay.
So if we're going to change that, we're going to have to lobby the state or the state legislator to change the penal law.
You know, it just seemed a little vague, because it does, like I said, it kind of lends itself to the interpretation that you can shoot somebody who's already committed a felony and maybe, you know, retreating or running away.
I got it. It sounds, I hear what you're saying, but we have to protect, you know, our policy lines directly with the Article 35.30, and I don't see a way around, you know, we couldn't remove that and still be in adherence with the penal law.
Captain, I think that we are in all of our comments about policy, we may point to things that we feel are vague or we're unclear about. We are very much so aware of the fact that all of the policies that exist within the policy book are part of an accredited process that you have gone through with the state. And just to let everyone know, White Plains Police Department, as of my understanding, went through an accreditation audit as of January 2020. Actually, that's this year, and they passed that. So we understand that. However, in looking at some of the policies, we still would question some of the language in the policies and some of the placement of notation in the policy, even though they might have been certified by the state.
Absolutely. I was just trying to explain that it wasn't like we came up with this as a standalone. This is taken directly from the New York State Penal Law, Article 35, and we have to stay in compliance with that.
And look, you can cite that in your policy book, you know, so that there's no question about it.
That's probably the best way we should do it. Yeah. We should probably notate that it comes directly out of. You're right. We should probably notate Article 35 in there.
So, Marie and everybody else, I kind of agree with you. I was looking at it and was somewhat surprised myself. Article 35 is mentioned in our use of force response to resistance policy, which goes hand in hand with the firearms policy. I am a little surprised it's not mentioned in here. That's something that we can absolutely will add to our firearms policy. But you know, some of the things they said, some of the nuances is you got to understand that when you're talking about against a person who's already committed a felony, so you know you got to talk about real life scenarios. I think part of that is what it is. It is saying that you have somebody who robbed a bank. I'm just using a scenario, and was armed with a weapon and killed somebody. When we go to arrest that person, even if it's later on, you know, we would operate under the assumption that that person may still be armed and capable of using deadly physical force against us or somebody else. It's not so much the act of if somebody committed a felony that we get to shoot them. And part of this is that New York State under Article 35 still does have on its books a fleeing felony provision that says an officer can shoot somebody if they are escaping or fleeing. I don't know the exact wording, if they've just committed a felony. But case law, which again, it should be here. It is in our response to resistance. It is something that we train on and let our officers know quite often, every year, as a matter of fact. Graham versus Connor, and some other Tennessee versus, I can't remember, but it does deal with, you can't do that. If somebody burglarizes your house and we get there and they're running out a back window and running into the woods, let's say, we can't just shoot them. And that is part of our training with our firearms, with our use of force, that type of thing. I know it's not easily understandable or in these manuals of the procedures and the policies, but it is when you take the training as a whole, it is in there, and that type of training starts in the academy. Excuse me. So I just, you know, sometimes there is some perspective that is needed here. In terms of what the procedures are actually saying. And much of the beginning of this, Section A, 1A and 1B, is taken right out of either Article 35 or New York State policies, model policies, just to delineate what is deadly physical force. And Article 35, I believe, actually delineates between a private citizen and a police and a peace officer and what they're allowed to do and not do. So we take all of that directly from Article 35.
I guess one thing that I would say, like overall in general, I know that a lot of these things do overlap, like firearms policy overlaps with response to resistance and so on and so on. But I'm looking at this stuff like it's all piecemeal, you know, it's firearms policy and then there's something else. I mean, I guess if I were to redo it, I would organize it a lot better, and maybe firearms policy should only speak to, you know, gun safety and that kind of stuff. And then this other stuff, you know, the use of deadly force should come under another section so that you don't have to go back and forth. But that it would be more, I guess, more of one policy book instead of like all these little separate ones. That would just be that's my you know, reaction.
So just as a point of information, we are making a recommendation for the overall format and layout and notation that takes place within all of the policies across the board we find that there's a need to provide updated, current, both case law and other notations that should go along with the policy. But we'll just briefly cover that a little later. I would ask that in order to allow us to kind of proceed through as quickly as possible, if it's possible to hold the questions down so that we can get through at least a few policies that we have noted, because there's a lot of detail, as you can see, within all of the work and effort that we put into this.
Right. Okay. And so the other recommendations you could see on the outline, there was reference to a shooting review board. Didn't really clarify like what that is, who, what it's composed of. Again, discharge of a firearm report should be done immediately, and officers should be interviewed immediately alone, rather than giving him time to think about it and so on. So again, those are our overall recommendations. They certainly can be added to or taken away, however, everybody sees fit, but that's pretty much it for there.
Thank you, Marie. I'll move on, and once again, please, if you can, give us your questions as we get towards the end of just the presentation of the few policies that we're going to cover today. Unless, Janice, you have any other recommendations as to how we should proceed?
Yeah. Just keep going.
Okay. So next we have the field stop policy, and that's going to be covered by Richard Willstatter, excuse me.
Hi. I hope you can see me and hear me.
Yes, both.
Okay, good. So with respect to the policy on field stops, the current policy incorrectly describes the standard that the Supreme Court has set for forcible stops. The policy should be limited to permitting forcible stops when an officer has a reasonable suspicion that a person has committed, is committing, or is about to commit a crime. No further elaboration on that is necessary, but the current policy has in part an incorrect permission for forcible stops. It also incorrectly describes the standard needed to conduct a frisk, which is separate from a forcible stop. A frisk is permitted only when an officer has a reasonable suspicion that a person who is stopped is armed and dangerous. Of course, there are times when an officer will have a reasonable suspicion that a person has committed or is committing or is about to commit a crime and is armed and dangerous. And under those circumstances, the Fourth Amendment of this Constitution of the United States and our state constitution permits an officer to rightfully conduct a stop and frisk. So what's important editorially here is that some police officers, notably in the city of New York, during the years when Mayor Giuliani and Mayor Bloomberg were running things, a stop and frisk program was instituted to stop and frisk minority youth in violation of the Fourth Amendment. We're not saying that that's happened here, but the policy should be limited for all police departments to only that which is permitted by the Constitution. Finally, the current policy says that officers may search a closed container or bag during a frisk, which is part of a stop and frisk. But actually, the officers can only touch the outside of such a bag to see if it feels like there's a weapon inside. Otherwise, unless there's probable cause for an arrest, in which case you could conduct a search incident to arrest, a search warrant is required. So those are the recommendations we made with respect to field stops. I will also cover the response to resistance policy. Now, talking about the response to resistance policy, the current policy says, quote, all members will not use unnecessary or excessive force. The subcommittee believes that the policy should be more straightforward. That is, that the use of excessive force is both prohibited and illegal. Rather than saying they shall not use it, we should say that it is prohibited, to make it more evident to officers that it's not permitted and is against the law. The policy should also make clear that intentional violations of such a policy could result in discipline, including termination and referral for prosecution. So next, the current policy says that officers may use only that level of force necessary in the performance of their duties within the limits established by the penal law, which is one thing, and then the case to which Chief Castelli referred, Graham versus O'Connor. That is a Supreme Court case that governs civil liability under what we think is a very lax standard of objective reasonableness without the benefit of 20/20 hindsight, is the way Judge Rehnquist wrote his decision many years ago in this Graham versus Connor case. That may be a limit of liability that the city or a police officer would have if he were sued for engaging in excessive force. But we, that is the committee, does not have to agree that police officers should be held to that lax standard. So therefore, we recommend that the policy should be that officers must not use excessive force and to use only the force which is appropriate and necessary and reasonable to the circumstances. So because the current policy has a much looser standard, what is objectively reasonable under the circumstances is a completely different thing from just telling people who are police officers, do not engage in excessive force. Next, we think that officers should be taught that the use of excessive force by police officers can and has been investigated by federal law enforcement and punished as a violation of the Civil Rights Act of 1968, codified as Title 18, United States Code, Section 241, that is, a conspiracy to violate civil rights, and Section 242, deprivation of rights under color of law. The reason we think that this ought to be taught to police officers is because we want to stress that from time to time, famously in the Rodney King case, and less famously in a case where I represented somebody who was serving 100 months in a federal prison now, law enforcement officials have been prosecuted right here in our district for using excessive force. So we want it to be clear to officers that this is something which is a serious matter. Next, the current policy says that officers who see the use of force, quote, beyond that which is objectively reasonable, shall intercede when it is safe to do so. Again, objectively reasonable is a reference to the Graham versus Connor case. The subcommittee believes the policy should be that any member present and observing another member using excessive force shall, when in a position to do so, safely intercede to prevent the use of such excessive force. This is a way of focusing officers on the use of excessive force being illegal and prohibited, as opposed to having to determine for themselves whether that level of force being used against a civilian is, quote, objectively reasonable. And finally, the current policy for the use of deadly physical force is wrong, we believe. It permits an officer to use deadly physical force, quote, in effecting the arrest of a person that he reasonably believes has committed a felony in which the use and threatened or imminent use of deadly physical force has been used by the subject. So turning to Article 35 of the penal law, it says the use of deadly physical force is necessary, may be necessary to defend the police officer or peace officer or another person from what the officer reasonably believes to be the use or imminent use of deadly physical force. But although you can argue that the use of deadly physical force can be used in certain felonies, it has to be for the defense of the officer, self-defense, or the defense of a third person, and so forth. So we think that the officer should be permitted to use deadly force, quote, when he reasonably believes it is necessary to prevent or terminate the use or threatened or imminent use of deadly physical force against himself or a third person, or to prevent serious physical injury to himself or a third person. The reason we think this is because we think that an officer's belief that a suspect has, at some point in the past, used or threatened the use of deadly force cannot or should not justify the killing of that suspect. Those are the recommendations the subcommittee has made.
Thank you, Richard. I appreciate you going through that so thoroughly. And once again, if you have any further questions, you can ask us, if you will, at the end of the next few slides that we have to present. The next is the review of a strip search policy. And just to let you all know that we've all gone through all of the policies, and some of the comments that are made on the policies are directly from individual members of the subcommittee, and but they were all presented to us, and we're all in agreement in some form or fashion that that the comments are correct. The purpose of the strip search policy, is to provide officers with the guidelines to determine when strip searches and body cavity searches are legal and necessary, and to establish guidelines for appropriate conduct of such searches. Were you able to hear me, everyone, with that?
Yes.
Yes, yes.
Okay. So throughout looking at all of the policies, there are places where we find that documents may be misquoted. And this is one of those, the first note is one of those areas where we have a citation for a PR 145, which is incorrectly cited and needs to be corrected to a PR 120, which does not exist, or vice versa. And that is, we find in several of the policies where we have that documentation misquote. Yes. So next is the points that we feel there should be revision is, for example, in there's a point in the policy that notes no arresting person will be strip searched, especially persons arrested for traffic violations, misdemeanors, under the arresting officer's reasonable suspicion to believe that the person is concealing contraband or weapons. Reasonable suspicion may be based upon the officer's the following. And the reasonable suspicion will be based upon the reasonable suspicion may be based upon, but not limited to, the following. And it was not included in there. So, but I can point to the arrestee's appearance and demeanor, the circumstances surrounding the arrest, the arrestee's criminal record, particularly past violation, violent crimes, and narcotic offenses. And we feel that this is an area that should be removed from this particular policy. And especially I take note of areas where we talk about crimes that of offensive narcotics, where you have someone who may be in use of narcotics like marijuana, opioids, or steroids that may be in effect legal and not criminal, but then are cited here as reasons for an officer to decide to make a strip search of that individual's person or body cavity. In addition, we feel that this other area should be removed from this particular policy, where it talks of the discovery of evidence weapons, narcotics, and contraband at a stage prior to arrest, which is somewhat saying that prior to a person being arrested, it may be determined that this individual has a weapon or some contraband that is hidden in their body persons, and therefore that they can be strip searched due to this assumption or premise that they possibly have this on their persons, and that this within the policy itself leads to, we feel, being something that is unfair because it is pointing to the situation where an individual may not be known to have it, but it is assumed that they have that on their person. And so that part of the policy should be removed. There was also a question for us that doesn't appear here as to who is able to produce the body cavity search. And from our understanding, that is in the policy that all body cavity searches must be done under the direction of a medical person to ensure that the suspect or the person or the person who's arrested is properly treated. Once again, this policy is one that we'll continue to go over as others, and as we find more clarity to our reasons for removing sections of the policy, we will make those known. Next, I'd like to move on to the go back up, the personal complaint policy. And I'd like to state that the personal complaints policy is in place to an allegation of improper or unlawful act or omission which relates to the business of the department or to the conduct of any sworn or civilian member of it. Some of the noted points to that also are improper act of omission refers to the abuse of authority, discourteousness or abrasive behavior, substantial deviation from acceptable conduct or performance, and unlawful acts of omission are conduct which would be criminal on its face, unnecessary or excessive use of force, and conduct, although not criminal, which is a deviation from acceptable behavior. So these points actually speak to the process of the personal complaint. Within the personal complaint policy, there are areas which point to how the complaint is handled. One of the key noted points is that a supervisor may take a complaint, and then that policy or that complaint rather would be passed along to the captain or to the chief of police, who in turn may turn that over to a department called the Office of Professional Standards. And from what we've come to understand, the Office of Professional Standards is in effect what is the old Internal Affairs Department. But in line with that, the process may then also be turned over to the DA's department, depending on the severity or the findings of the previous investigations. And then that, in effect, also turned over to some commissioner for evaluation. And then once the complaint has been thoroughly evaluated, it will then be reported back to the complaintee as to the status of that complaint. And that's generally the process as to how these complaints are handled at present. I find and have made comment to within our committee that the Office of Professional Standards and the approach in itself can be a bit of a black box. And what I mean by that is if I'm a citizen or a civilian and I turn to an officer in the field and I say, I have a complaint, how do I submit that complaint? Well, this policy doesn't actually give me a warm and fuzzy as to how I would do that. I understand that I may be asked to speak to a supervisor and have that supervisor take that complaint down. But the processing after that point, I may not hear anything about until I get a letter in the mail, as it is stated in the policy, that the process has been gone through to review the complaint. However, from my point of view, if I don't have an address, then I may not hear about what happened with that policy. And that may be an example in case where you have someone who is homeless and they may have an issue with making a complaint and not be able to understand how that complaint was handled at the end of the day. In mind of all of that, I think that it would be best that a new process be brought in place to deal with the issue of transparency for complaints from civilians and citizens. And the process behind that could be that a document process should be created to clearly outline the process for civilians and to submit complaints. Also, that the nature of the complaints, all police personnel, date, time, location, and any adjoining evidence provided should be and must be documented. The process must include complaint number, a methodology to allow for the tracking and the getting of updates and the status of that complaint to the civilian. The system should also operate as a problem trouble ticket, as you get when you call any major business these days. That trouble ticket, when you get online to speak to someone, you can refer back to when that was entered and how it happened, and you get a notice from them as soon as you're putting it in that this is being recorded for quality purposes. So there should be some documentation behind the submission of that complaint. A document management system will be best to implement this, and all citizens would have access to that document management system in terms of their complaint by having that reference number to the complaint, which would possibly be able to be recovered by using some online system to look at the status of their complaint. All complaints should be electronically documented and filed in a document management system throughout the investigation process. An evaluation of each point that complaint hits, whether it be the supervisor, the Department of Professional Standards, the DA's department, or any other entity, should be documented and be able to be tracked on this particular system. And any paper or other entity that goes along with the evaluation or investigation of the complaint should be able to be connected to that particular complaint via a system notification, and then should be also kept in some form of data management. Civilians' complaints must be able to be receive updates and notifications referencing the status of the complaint. And then finally, the date time signature should be applied at each point at which the complaint is received. And final reports should be electronically available to all parties. So this is more so taken into consideration that this allows for more transparency of how complaints are handled and how they are processed through to allow for citizens to feel that and see that their complaints are adequately being administered. So next, just like to make note that all of the policies that we reviewed, we feel need some sense of improvement, whether it be readability, policy names, policy name number placement. Some of the policies have a date that's on the bottom bottom right-hand corner, which in some cases could be confused with a page number, and being able to have that at the top of the page would be much more clear. Section labeling, page labeling, date the policies were created at the top of the page, as I said, in addition to including the notations from other sources, for example, statutes, laws, and policies, and cross-policy references should be included within the policy. The creation of new policies to address operating changes is definitely necessary, and retirement of outdated documents and policies as per the New York State Department of Justice. With that, we're at the end of making comment in terms of the policies that we've reviewed. And this, for example, is just a few of the policies that we covered in order to allow us to report to the General Committee. Janice, if you have anything that you'd like to add to that?
Yeah. We did talk about the implementation of a CCRB with the personnel complaints, so that we did make some suggestions, and I thought that was going to be a recommendation of for personnel complaints. Also, we also talked about, we haven't seen any policies that address discipline of officers when they do misconduct, when they do wrong. So I don't know if you have policies on that, or if you just, or we just didn't see it. But we were interested in seeing policies on discipline, because we have some feelings that because a lot of the policies don't address what happens when the policy isn't followed, that leads to problems.
So yes, you're right. And as you said, and as we had mentioned earlier, this is just a first pass at several of the policies that we've looked at so far. And we're going to actually continue evaluating and adding more substance to the recommendations that we make. This was in order to try to allow us to give an overview of the things that we've done so far and the policies that we have reviewed so far in depth.
Yeah, I was wondering if one of the police officers, whether the captain or the chief can let me know whether there are policies on discipline.
So we have a whole thing, and I guess I can make it available to whoever wants it. Duties and responsibilities, which cover discipline in the way that certain things that are expected of officers and what can happen. Most of our discipline is covered through the contract. I guess that would be the procedural part, but the discipline in and of itself is it's more. I don't know if I understand exactly. Like, if you do A, this will happen. The punishment will be B. Is that what you mean, Janet?
Well, you make your policies very clear as to you. Let's use response to resistance.
Correct.
What will happen? You say that they should not use excessive force. They should not use what is unnecessary, but you don't say what will happen if they do.
Well, I mean, there's no, it depends on the circumstances as to what the department can and have the options to do. Obviously, if it's unnecessary and excessive and it's criminal, we're going to let the criminal aspect of that take precedence, which would not necessarily be out of our hands. But let's say we have somebody who was used excessive force in the sense that they handcuff somebody and put them on the ground when they didn't have to, or something along those lines. I'm just using a general example where excessive force does not have to be the horrible examples that we see where it leads to serious physical injury or loss of life. For our purposes, it can be just not appropriate and reasonable and authorized under the circumstances. That it could lead from anywhere to retraining and counseling and having an understanding if reviewing the person's training to suspension, and depending on severity, reoccurrences, the totality of the circumstances. So I understand what you're saying. You don't have anything that says that if you do A, B can happen, but I don't know if that is something that is doable. Some departments have a matrix on discipline. I don't know. It's certainly something that can be looked at and recommended. But I mean, it's very flexible with us, and I don't mean that. I know that the impression is going to be it's flexible because we're looking to minimize, and that's not the case. It's just it is specific to exactly what happened.
I think when we're trying to get the community to trust the police department, that they'd like to know that there are consequences, accountability. So when I was looking at the policies and I didn't see any of those things, it just makes me wonder, are there any?
There are.
So I think we should work on maybe putting some in place.
If that's a recommendation, it should just be a recommendation. I mean, my personal opinion is it's the prerogative of the chief to mete out discipline, and you can't prescribe every single instance of if someone does this, you will get that. Because what will happen is if an officer does something that hasn't been prescribed, they're going to hold you to that. Well, it hasn't been prescribed, so then there's no discipline for it. So I think you need to allow some flexibility, and it is the prerogative, and it should be at the prerogative of the chief to mete out discipline.
And there is, when we go over policies, procedures, duties, responsibilities, you know, the officers are instructed that they are required to follow these under the penalty of some type of discipline. And I think the fact that the fact that we do discipline on a regular basis for violations, it just reaffirms that there is the discipline. That is, and again, I understand what you're saying, that the public is not aware of what we do. Most of our stuff is the administrative violations, there's really not a whole lot in terms of a external complaint concerns. So, but I understand what you're saying. It's something that I said. I think if it's a recommendation that we work on something like that and work towards transparency when it comes to discipline on our officers, I think that is certainly understandable.
Thank you. Any other questions, comments?
I have two very brief comments. So thank you, this committee, for all the work. It looks like you've been doing a lot of detailed work, and I appreciate it. The section that Marie covered on excessive force, I'm just wondering if, in my networks, what civilians want is for law enforcement to use the least amount of force to get the job done. Even if a person has committed a heinous crime, whether with, you know, a firearm or with a knife, the general public wants that person to be brought to justice in a court of law. We'd rather not have our law enforcement executing people if possible. So I'm just wondering if we could use that language, the least amount of force to successfully conduct a police operation. And it does bring up the subject of a person wielding a knife. It's not in the policy. And I know that a knife can cause serious bodily harm or death, but I think the general public also wants to feel that our law enforcement are being regularly trained in how to capture a person wielding a knife without using deadly force. So I just feel like that was not captured in what your committee came up with. The other point that Richard was covering with resistance and resisting arrests, there was no mention of, you know, interacting with someone who has some perhaps mental weakness. For example, in the very high profile case of George Floyd, he was telling the police officers that he's claustrophobic and he's not able to get into the back of the police car. And that's a real condition. So what do the White Plains police officers do when someone they are trying to arrest is telling them that they are claustrophobic and cannot get into a tight space? If the officers force them into a tight space, the person may panic, may try to flee, and it may cause a very undesirable outcome. So these are questions I have that were not addressed in your policies, but I do thank you.
Thank you, Nada.
Patrick. Well, maybe I can address some of these things if there's time. So it strikes me that we could make a recommendation to the police that they use the least amount of force reasonably necessary under the circumstances. But, you know, that as a general policy, that's something that we can consider as a subcommittee to whether we should make such a recommendation. What we focused on is prohibiting excessive force in a more straightforward way, regardless of what the standards might be for potential civil liability to the police department. Because what we thought was that, whether the officer or the city could ultimately prevail in a civil case should not govern necessarily what we want officers to do, which is to avoid the use of excessive force. But, if we recommend that the least amount of force be used as necessary under the circumstance, again, that permits a certain degree of discretion, which, that's okay, but we didn't focus on that. There is a policy for people, for police officers approaching people with mental health issues. We haven't gone through that carefully. And so I think this is sort of a separate policy that the White Plains Police Department has, and we really haven't gotten to that, I think.
Thank you, Richard. Thank you.
And can I just jump in really briefly? When you talk about like people with mental health issues, there's a lot of overlap, between and among all these different policies. So I actually think that there might be a subcommittee dedicated to working on issues with mentally ill. So I don't know if you guys can correct me if I'm wrong, but there's a lot of overlap is the bottom line. And it's hard to know where one stops and where the other one starts sometimes.
Got it.
That is absolutely the case. I'd just like to point out that our committee, I think, has continually gone over policies not only once but twice, and continue to do so. And it's important to recognize that it does take a lot of effort. We are not police officers involved in the process, but we are citizens with an eye on making sure that there is transparency to the policies that exist. And just as a point of information for everyone, there are, from what Chief Castelli has told me, there are 24 policies and 110 procedures within the book of policies and procedures that exist. That should be noted for everyone.
Okay. And I just want to remind everyone that these policies are on the website. So I would encourage you to look at the policies and let the committee members know if you see something that we may have missed, or you see something that you think is something that we should address. The policies are on the website. So look at them.
Is this something new as a result of our task force forming?
I don't know.
Nada, this is this is Karen. When Janice just said it's on our website, it's our Police Reform Committee webpage. There is a link on that page to some of these policies and procedures that you've heard discussed today. The PD has provided them, and then we've posted them publicly.
So it's not on the police department's own website?
That I cannot speak to. I would.
And Karen, can you make point also that not the entire 24 policies that exist are on the website that you're referring to for us, only the ones that we were handed, am I not correct?
Right. Okay, so because we have to cut it short.
Bernie, can you stop screen sharing?
Yes.
The work for the Policies and Procedures Committee continues. It's a lot of work. So we have to continue with the discussion, but feel free to email us, look at the policies, and make recommendations that we can look into. So Patrick Shelley, you on the,
yep.
You there?
Yeah, I just have one quick, so I know you brought up the question, Janice, about tracking police misconduct. So Bernie, I just sent you an email of a document that has some good recommendations, and I wanted you to know that we did include some recommendations as well under technology when it comes to tracking police misconduct, because we feel like that it belongs to technology in a sense as well, and it will also have to partner with recommendations from policy and procedure. It would be developing a offenders registry that identifies officers that have been found to commit significant or insignificant acts of misconduct and or crime. And then this would be shared not only within New York State, but probably on a national level. So I know this is something that a lot of police, people in police reform have been looking into. It's similar to what we use in child welfare, like the Justice Center. So I just wanted you to know that that is something that we included in some of our recommendations as well.
Sounds good.
Thank you. And I'll take a look at that, definitely. Just as another point of information, the policies are available to officers now, from my understanding, on their cell phones. So there is active data that they can rely on and refer to immediately. I think when my group, the subcommittee, had two opportunities to actually meet with the police department at the police department headquarters, and we were introduced to the direct report to the chief of police, of which there were 4 commanders, of which Captain Spencer is one. And there is a one commander who's responsible for data and information management. So definitely we should talk about that even further and look into that further.
All right,
we should move on.
Patrick, are you ready to make some recommendations for your committee?
Yeah, I can go over some. How much time do we have? Are we going?
Well, yeah, we only have about 15 minutes. Do you need more time than that? Because if you do,
we want to shortchange.
We don't want to shortchange you. So if you do, we can schedule you for the very first one to go next week.
Yeah, I think that might be better, just because training is pretty extensive. So
right, and we don't want you to be shortchanged. I do want to Wade. Wade had made a recommendation, or he had made a suggestion. Wade, do you want to talk about that a little bit?
You mean my suggestion about doing the police reform like 5 or 7 years from now?
Yes.
Yeah, I mean, basically, the way I look at it is, the governor submitted this executive order that all police agencies in New York State has to conduct a police reform committee. And when this is over, this may never happen again. It never happened before. So I'm recommending that one of our recommendations is that the city of White Plains conducts an addition, a new police reform committee. It could be some of the same people, it could be different people, but it could be every 5 years to 7 years, just to go over the current state of affairs, see what was missed or what was not being followed in this reform committee's, recommendations, etc. So I feel if we make that suggestion and recommendation, and the city, accepts it, that could be something that can definitely help the city moving forward. Because right now we have Chief Castelli and Captain Spencer, who are, and also Brian Johnson, PBA president, who are all, sharing information and supporting this. But who knows who's going to be, sitting in those seats 7 years from now. So it'd be nice if the city could, make it a practice and a policy that this happens every 5 years, 7 years, whatever, you all feel is proper.
I think that's awesome, and definitely should be a recommendation that we make. I don't know if we want to do 5 years, 7 years, but that would be up to us to talk about. 3 years, 5 years, 7 years, we can talk about that. Maybe we don't have to talk about it now, but I like that idea, and I'm pretty sure the committee likes it.
Yeah, Wade, I believe it's a great idea. I would also say that maybe we have a follow-up even to the submission, to the completion of this committee, that maybe in a year's time, we're able just to do a refresher overview with the members who are here now to see how far our recommendations have gone. Maybe not that we go through the entire process all over again, but just that we had a session in which we're able to review where we stand at that time. I think the public would really like to know that also. So
Yeah,
that would be great.
Okay, that's a good one, Wade. So we got time for maybe another couple comments, short comments. Karen has to get out of here. Anybody else? I haven't heard from Brian. Brian, do you have anything you want to say? Can you think of any barriers that we may come across?
Barriers? What do you mean by barriers?
Like anything that might keep us from, from a union perspective, that might keep us from doing some of the things that
not as long as I'm at the helm. No, I think that along with Chief Castelli and Captain Spencer, I'm all about implementing anything that we do here. So the only way that could change is if I'm not the president any longer, somebody else is. That I can't speak for them.
That's good to hear. Thank you, Brian. Okay. Everybody else okay? When's our next meeting, Karen?
Next Monday, 12 o'clock.
Okay, everyone. Patrick, you're going to go on first next Monday, and whoever else is ready can go after Patrick. Let us know if you're ready.
Katrina, will transparency and accountability be ready by next Monday?
Yeah. Okay. I want to meet with my committee first to confirm, and I'll get back with you I'll get back with you during the week.
And who else is left?
Okay.
Can I just jump in for 1 second? I just want to let Katrina know that Wednesday at 3:30 will be good for that subcommittee meeting with Sergeant and Detective that is in charge of the Office of Professional Standards. So if Karen can set up a Zoom meeting for us on Wednesday at 3:30, I'll send you the emails for the other folks that need to be on the Zoom, if that's possible.
Sure.
Thank you.
Thanks, Captain.
So our next meeting is the 14th at what time again? Just to be
12
clear?
o'clock.
12 o'clock?
Yes.
Thank you.
All right. Okay, everybody, have a nice day. Enjoy the rest of the week.
Same to
See
you.
you on Monday.
Thank you.
Thank you.
Thank you, everyone. Bye. Bye-bye.